Item number 15, new motion, which Millard has kept after vacation ending.
Yes.
Item number 15. Yesterday, Millard has passed two similar orders, but exactly identical matter. It won't take more than 30 seconds.
Yes, all the matters are identical. If I take the matters.
See, the warrant is pending. Otherwise, but I won't have made this request.
No. Come on next circuit.
Kindly,
I would not have
more than
time.
10 seconds.
I have to leave the staffs.
I have brought the order also. Yesterday's order will only the FIR name, FIR number has to be changed.
No. Come on next week then.
The warrant is pending. Otherwise, I won't have travel your much. Any time, 11, 11:30.
No.
Kindly, 12 o'clock.
Today, no mentioning.
It's not a mentioning. I'm praying for the ground of urgency. The warrant is pending. Otherwise, I won't have travel your much. I brought yesterday's order also.
If I allow you, then all the persons are there. They have to be allowed.
My case is not this thing because
every case is urgent. They go to High Court.
That's why
I understand why you not mentioned the yesterday.
It was supposed to come, but I was not aware that this will create a new heading.
I have also already directed that on the second half that all matter will be taken up after that.
I was not aware of that. The warrant is pending. Otherwise, I know.
No, today it cannot be under. Yesterday I have done the matter all.
First, the FIR.
No, you come after vacation.
The warrant is pending.
I understand.
12 o'clock, 12:30.
My lordship.
Yes.
My lordship, may I? My lordship, may I?
379, whatever has been passed, but just uploaded in my matter, just 315, which is a new motion.
Listed.
Lordship, for correction, lordship, yesterday, lordship has
Yes,
passed
correction.
an order. Last page, it is corrected, lordship. It is last page. Yes. My lordship, may I mention a matter for correction, my lordship, in order, my lordship?
Yes. Correction. Give me the order.
My lordship.
Correction. What correction?
My lordship, for correction.
This matter.
This matter is my lordship. Yesterday has passed the order, lordship. GR case number, lordship, is wrong, lordship. Last page. It's supposed to be 563, lordship, but it is 363.
Okay, only number is
Wrong, lordship.
GN number was
GN.
incorrect. The correction code. Okay. ওইটা ওই যেটা মেনশন করলো হ্যাঁ দেখুন উপরে নাম্বারটা হচ্ছে yes
with your lordship's kind leave, my lord. May I have your lordship's
where is
kind
your
leave?
where is okay
My lordship,
yes
my lordship, my matter, an order has been passed on 3rd October 2024 in connection of CRR case number 380 of 2024. There and stay order has been given by this honorable court. In that stay order, the court's name has been. My lordship, can I speak in Bengali, my lordship?
yes
মাই লর্ডশিপ, ওখানে কোর্টের নাম দেওয়া আছে কিন্তু কোথাকার কোর্ট সেটা দেওয়া নেই। আলিপুরদুয়ার যে এটা লেখা নেই মাই লর্ডশিপ। My lordship, the paragraph has been written that considering the entire facts and circumstances and considering the material on record, there shall be a stay of further proceeding of special case number 43 of 2024 now pending before the court of the learned additional district judges court, special court, SC and ST prevention of atrocities Act 1989 for a period of 8 weeks from the date. My lordship, there is
Where is the
which
order?
court where
Where is the order?
Alipurduar.
where is the order? Give me a copy of the order. Is there anyone to
My lordship, no, my lordship, there is nobody. I can send in the chat box, my lordship.
okay what is the number 324
No, my lordship, CRR case number 380 of 2024. 380. Yes, my lordship. My lordship, the courts where the courts present that district has not been mentioned, my lordship.
okay very well what is the date of order
My lordship, 3rd October 2024. 3rd October.
okay
And my
Mr.
lordship,
President, Okay,
there is another matter, that is there is not all the petitioners present in that before the learned court, that is mentioned here. My lordship, except petitioner number 4, that is my lordship,
Okay,
my minor brother.
okay, I understand.
My lordship.
Okay, I understand.
This only correction, my lordship.
Mr. Bhattacharya,
With your lordship's kind leave, my lord. My lord, I'll just refresh my lord's mind. My lord, day before yesterday, I had sought for a leave, my lord. My lord was kind enough to grant me leave to file the revisional application on the basis whereof, my lord, the matter was to be listed today, my lord. No matter the matter has been listed, it's appearing as serial number 19 in your lordship's daily supplementary list, my lord. But I understand, my lord, there's some inadvertence, my lord. It has been mentioned, my lord, that these are all to be taken up after vacation.
your item number?
My item number is item number 19, my lord.
Okay. Yes, you have mentioned it.
My lord.
Very well. I will call it. No issue.
Grateful to your lordship.
Call the list.
item 1 and 2.
Two appeals are there, one by insurance company, another by claimants. The appeal of insurance company, appeal of claimants is on the ground that the income of the deceased. I follow the observation of Honorable Apex Court in Mallar VG and others versus United India Insurance Company Limited. According to that observation, the last year income appearing in the ITR is taken to be the income of the deceased. Accordingly, the income of the deceased is fixed amount of rupees 17 lakh 4,358. Regarding insurance company's appeal is mainly regarding contributory negligence. In respect of contributory negligence, my finding is the IO has observed in the CS that the victim, while driving the car, tried to overtake one vehicle and hit the offending truck face to face. By such accident, the deceased died on spot. However, it further appears that the IO has observed the offending truck was driving in a rash and negligent manner. If it is considered to be true regarding the fact of accident, it is not unnatural for a driver of a vehicle to overtake another vehicle in a highway if he finds there is sufficient space to overtake. The IO of this case is of specific opinion that the accident was happened due to rash and negligent driving of the driver of the truck, and the truck driver made an accused of this case. So it appears that stray observation of the IO in that particular case cannot be said to be the sole cause of accident. Moreover, the IO was not present at the time of accident. Rather, PW2, who was present at the time of accident, has deposed before the learned tribunal regarding the fact of accident. The evidence of PW2 and credibility thereof was not second during the cross-examination. Furthermore, the insurance company has the option to produce the IO or the CS witness from whom the IO has received such information during investigation. In this case, the insurance company has not opted such procedure. Moreover, the contributory negligence has not been specifically pleaded by the insurance company at the time of filing written statement, and that was not also proved by producing cogent evidences. Merely because of head-on collision, it cannot be said that the victim vehicle was responsible for the accident. The judgment referred by the learned counsel for the insurance company are factually different. No reliance can be placed upon them. Moreover, in all the cited cases, it has been specifically proved before the Honorable Supreme Court and Honorable High Court that the victim driver was negligent. But in this case, negligence on part of the driver was not been properly proved, neither on the principle of beyond reasonable doubt, nor on the basis of preponderance of probabilities. In a criminal case, charge sheet is not a piece of evidence. It is the opinion of the investigating officer regarding prima facie occurrence of crime. The prima facie finding in CS can never be treated as a documentary evidence. The evidence of CS witnesses in the trial can only be relied on as specific piece of evidence. The prima facie observation of the IO in CS has to be corroborated before it being used as evidence. In this case, the insurance company has failed to prove the opinion of the IO by way of corroboration. Under the above observation, the plea of contributory negligence as raised by the insurance company is turned down. It has already been discussed earlier that the employment of the claimant number 1 in the said concern cannot be construed as a income of the family. The claimant number 1 is earning by using her labor and capabilities in the said concern. The loss of income as provided under the provisions of Motor Vehicles Act for the death of a deceased cannot be equated or decreased due to the latter employment of any claimant with the said concern. Thus, the argument on behalf of the insurance company regarding no loss of income is not justified. Under the above observation, the annual income of taken to be 7,04,385. 1/3 the deduction is there. Multiplier is 11. Future 10% future prospect considering the age of the victim. General damages 70,000, as well as 20% of the general damages as the judgment is passed after the 6 years of the judgment of pronosticating. After adding all head, the award comes to rupees 1,38,32,491. After calculation, the just and proper compensation of this case comes to rupees 1,38,32,491. The insurance company is directed to pay the compensation together with 6% interest per annum from the date of filing of the claim application till its actual realization. The insurance company is directed to pay the compensation through the office of the learned tribunal within 6 weeks from the date of passing of this order by issuing 3 equal account pay checks in the name of the claimants. The check in the name of a minor claimant, if any, should be received by her natural guardian mother.
Now they are not minor.
And shall be follow the direction of the tribunal. The payment of compensation is subject to ascertainment of payment of deficit court fee, if any. This question. এটা কি অর্ডার দিয়ে দেবো? আচ্ছা আচ্ছা। দেখুন সেকেন্ড পেজে করা আছে দেখুন। Yes,
May it please your lordship, my lord.
yes.
This matter, I'm appearing on
My
behalf
lord,
of the
this is-
respondent.
My lord, I'm appearing for the petitioner, my lord. This is my
But this has
application
come up
wherein
at
my
our
lord,
instance.
My lord was
mentioned
pleased to
this
pass an
matter.
order of stay in terms of my lord's order dated
Lord,
23rd
please,
September
it has come up at our
2024.
instance, my lord. Mr. Das can kindly rest himself.
My
Lord,
lord,
come up
the
at
issue
our
is, my lord,
instance.
there is a direction for the matter to appear on 8th of November. There is a direction for affidavit on the respondent. Unless, my lord, this process is completed, my lord, no hearing in the matter can take place, because today he might have mentioned, but then I am in a handicap to appear before my lord.
They have mentioned it, they have mentioned it.
Absolute incorrect submission. Kindly take my note, my lord. Take to Judge Sahab ke devan, please. Absolute incorrect
My
submission. Kindly take my note. Lord, kindly come to flag mark number 1.
No,
My
what
lord,
is,
may kindly hand
Lord,
over a.
there is a stay, and in this stay, by my lord, relying on a coordinate bench judgment, there has been stay of proceeding. Lordship kindly takes up flag mark
stay
number
of
2.
proceeding is there.
In the trial court, the title suit, which is a suit for eviction. Lordship kindly takes up your lordship's last order that
Yes.
I have, my lord, flag marked as flag mark number 1.
My lord, I am not benefited with a copy of the document, my lord.
Lord, I have sent
He's
it to my learned
submitting.
friend. I have sent it to my learned friend.
No, today difficulty is there is a resolution of bar. If
No, but
both
Mr. Das
party
is
ready,
appearing.
if
Mr.
both
My lord, I am not ready, my
Tell
lord.
Mr. Das is
This is at a
appearing.
short notice.
Mr. Das is appearing, my lord. Your lordship
What is
kindly
the
sees, my
permission?
lord,
My lord, I am appearing to indicate that I am in some difficulty. My lord will kindly direct it to come up on a different date.
This is their
Okay,
ploy.
just wait, let me hear
Lord,
out.
kindly hear
Let me
me.
hear out.
I request your lordship to kindly take mark flag mark number 1, which is your lordship's last order. In your lordship's last order, your lordship had taken into consideration 2 things. 2 documents have been marked for identification before the trial. None of the parties want those documents to be acted upon. That is, your lordship sees X1 and X2.
Yes.
Now, they relied on, this was happening ex parte ad interim. Your lordship, they had relied on Bishojit Chakraborty versus Meera Sen Ray. Your lordship has recorded that. And relying on this judgment, they wanted to say that the trial court should suo motu impound. Suo motu impound, because that is the submission recorded. And your lordship has stayed the proceedings of an eviction suit.
Yes.
I will only show one paragraph from Vishwanath Chakraborty's case itself, which says that suit cannot be stayed. Because this should have been shown by the petitioner themselves. They are relying on a judgment on paragraph 16, but they are not showing your lordship paragraph 18. At this, that's the reason why in this hurrying up stage, they will not allow me to talk. The second issue is that suo motu, the court will never allow. 2006 Supreme Court judgment is there. These are the 2 things I wanted to show your lordship.
So today you want to hear this matter?
My lord, nothing has been decided by the trial court. Your lordship will keep the matter open for the trial judge to decide. I am not saying that decide the issue here and now. It's an impounding case. The original instrument is not before the revisional court.
Yes.
It's absolutely jurisdiction of trial court. My lord, kindly takes up, my lord, this one paragraph I wanted to show. Kindly take up the judgment which they had shown, my lord. I have given in my compilation. Kindly comes to flag mark number 2, my lord. Flag mark number 2. This is their judgment. This is the judgment of Bishwajit Chakraborty versus Meera Sen.
Yes.
Now, my lord, kindly come to paragraph 16 because that is the paragraph which they had shown.
Yes.
My reading of the provision of sections 33, 35 such and such is that when a document is tendered in evidence by a party and an objection is raised by the other side, the document is insufficiently stamped. At that stage, the court assumes the jurisdiction to impound the document as it was obligatory to apply the mind of the court in accordance with the relevant provisions of the said act. The object of section 33 is to protect revenue. As such, the court or such person as referred to in the said section must, however, exercise powers as envisaged under the said section, if necessary, suo motu, irrespective of raising objection by any of the party. Now, my lord, kindly see paragraph 18. So they say suo motu, there is no objection raised by them as recorded in the impugned order. They didn't. In the case of Sri Om Prakash Gupta versus Srimati Saraswati Shaw, reported in 2002 1 CLJ 452 Bhattacharya J. This is Milord Justice Kollanjyoti Bhattacharya, the Bhaskar Bhattacharya's judgment. I have also annexed this. It is therefore clear that a court cannot force a party producing a document to pay the duty and penalty assessed, but it is, and to have the document admitted in evidence. It is for the party to elect whether it will accept the assessment of the court and will get the document admitted in evidence, or to apply to the court and will get the and send the original document under section 38. But if a party decides to apply for sending the document in terms of 38(2), it cannot at the same time ask for the court to stay the suit pending the decision of the collector under section 40. Now, the scheme provided in the Stamp Act is exhaustive and does not approve such course. So, my lord, court has gone on to the extent to hold, even if it is pending before the collector, stay of suit can never happen. That is not envisaged under the scheme.
Yes.
And my lord, as far as suo motu
My
is
lord, I concede to this point. Let the suit proceed without these documents. Let them be taken out of record. I concede to this point.
why taken out
My
of
lord, there
Trial
is
court decide
some
this.
problem. My lord, there is some problem with regard to today. The matter cannot be heard. My lord, if he's
Let
he's
Mr.
trying
Das
to
come
indicate
prepared
there
on
were
any other day.
four other
Stay of suit cannot happen.
judgments. There
I
were
have
four
shown
other
you that the
judgments that I had
judgment
to
which they
indicate to my lord.
They
My lord,
should
the
have shown
particular
this to your lord.
judgment is factually different. My lord, my learned friend cannot pull a fast one
This is
like this.
their judgment.
He is trying to
But today,
again. He's also
Well,
misleading the court by saying I
things
have
can
not
happen.
raised any
Okay,
objection.
just wait, just
Lord,
wait.
I'll be
My
fair. Two things can happen. One thing I must tell your lordship, 23rd September's order, your lordship has written, served to the respondent by registered post.
Yes.
They have not done it. Yesterday, day before yesterday evening, they sent it to us. Matter was there before the Darjeeling court yesterday. Now, this is the ploy which the defendant wants to do in an eviction suit. Lordship has seen this through years. What is the conduct?
Yes.
But irrespective of that, stay cannot happen. I have shown it from their judgment itself. So, your lordship will vacate the stay. If Mr. Das wants to ventilate the grievances which he has alleged in the petition, he is most free to do it. It is his application. I cannot stand in the way. But what I can propose is, your lordship can keep this issue under section 33, 35 of the Stamp Act open for the trial court. I am not coming in the way. Lordship kindly takes up the application page 91 once. Nothing has been decided by the trial court.
I understand.
So this is open. Nobody will be prejudiced. And even this matter can be disposed of in this
So
term.
today,
Qualified remand.
that the matter can be disposed of, Mr. Das?
No, my lord. The matter cannot be disposed of today because of two things. My lord, my point taken is that the document had to be sent for impounding.
Very well,
My
very
lord,
well.
apart from this
And
judgment,
what
the
about
judgments
stay?
I would rely on.
What about stay?
My lord, the stay is actually for the benefit of the petitioner, the respondent, because I can only agree if he says that he is not going to take those
Not
documents
for my
out
benefit,
of the
it is my
record.
suit.
Okay,
Once
okay,
he
very well. So,
agrees not to
don't
rely
want
on
any
those.
stay. As the both parties has appeared, I will fix the date of hearing of this
My-
matter.
my
And
lord
you
will
will not do the
vacate
stay
this.
of this matter.
My lord, the stay should be there because my lord, it is fixed on
Their
8th of
judgment
November.
says they will not
Now
be
both
there.
parties has appeared, I will fix the date of hearing of this matter.
My lord will then take up. My lord will fix a date. My lord will fix a date, and the stay to continue till that date because
No,
what
not
they
at
will
all.
do is tomorrow they will try to
Their Vishwanath Chakraborty is their case.
What is the next date of this court?
There is no next date fixed. There is no direction for affidavit. That was their opening statement. They're always misleading the
What is
court.
the next date before the learned trial?
Today,
Today is the date.
yes, and your lordship knows that in Darjeeling district, there is no vacation. Like us, we have 1 month vacation. But Darjeeling court is functioning because it is only in December and January that they go for the annual vacation. So suddenly the suit will be stayed. And their own judgment says that suit cannot be stayed. It is Justice Kolanjyoti's
My
judgment.
lord, in the
has
interest
been-
of justice, my lord will
has
only
been
see
followed
today.
by Justice
If he
Prabal
takes out
Mukherjee.
these.
And they have shown this judgment.
My lord, I have judgments of 2011 by Justice Dipankar Datta, which I wanted
No,
to show on the
these
previous
lying
day.
things
My
cannot
lord would
happen.
recollect. My lord, I am addressing my lord. My lord will kindly listen to me. The particular document, if is taken out of record, it is the basis of the agreement, is the basis of their suit. If they do not want to have the document stamped and brought on record, I have nothing to say. I am merely willing to
How
go
you
ahead
want
with the
this,
suit.
want the
Let the-
plaintiff to take the undertaking like that before the revisional court?
My lord, that is the
I have
problem.
Supreme
Unless
Court
that is
judgments.
there,
I can show
unless
it
that
here
is
and
there,
now.
my lord,
that
let them put that on
what the law
affidavit.
is.
Okay, okay.
My lord, let them put that on affidavit and let them put it on
be
affidavit that I
stayed.
did not object to this document when the documents were tendered.
Very well,
completely
very well.
misrepresenting and
If he is
just
not objecting to the document, my lord, I have, my lord,
Okay,
referred to a
okay,
Supreme
hard,
Court
hard,
judgment.
hard. I have
My lord will
already-
kindly mellow down the stay, will not continue with the stay of proceedings, and then we'll fix the matter for hearing, my lord. We are ready to cooperate.
Well, today
No,
I am
Justice
in a
Solanduti-
handicap and he tries to mention and tries to get this stay vacated. This is
23rd September's order. We
uncalled for.
don't even
The
serve.
matter is
We have
listed
not
on 8th
complied
of
with the
November.
lordship's order.
The matter is listed on 8th of November. If
It is
my
not-
lord thinks it
not
will be
listed.
correct, my lord will pass necessary orders. This is listed before my lord. My lord has fixed it by my
Nowhere
lord's
it is
order of
written.
23rd
What is my
October.
learned friend saying?
My lord, I am
No
I am
direction for
only trying to
affidavit,
indicate-
nothing. He's saying it's listed on 8th, it is not mentioned in the order.
You are appearing for the opposite.
But I am
party on this
appearing for the opposite party, my lord.
matter. Okay, please take down.
My lord, I wanted to indicate the fact that it cannot be stayed. I have also, my lord, annexed the judgment of Om Prakash Gupta, Bhaskar Bhattacharya's judgment, which is quoted in Justice Subra Kumar Mukherjee's judgment, my lord. That
My
is-
lord, I will reply to these judgments.
It's
I
there.
will reply to these
They
judgments.
deny. They've got an order by showing the judgment and now they are denying their judgment.
My lord, I will reply to these judgments. I have just received copy of the note
Yes, you can reply.
judgments there.
Their own judgment, they should have shown paragraph 18.
As the opposite party has appeared, I think it necessary to pass an order. बोल हाँ? Opposite party is the plaintiff before the learned trial court.
Yes, my lord, in an eviction suit.
My lord, I had appeared only to indicate, my lord, that I am in difficulty today. I cannot address my lord in this manner because this requires hearing. My lord will kindly keep it on Monday, Tuesday, any date. I
Today
will
is the
address
last
my
day
lord.
today is the last day of circuit. And they have, this is their,
My lord, even in that case, my
they
lord
should have
will
served
keep
it. 23rd September order, they serve it day
My
before.
lord, I have served it. My lord, the issue is now Mr. Banerjee is there before my lord and is trying to have this matter, the stay
Please
vacated
do not prejudice the
without
court
me
in this
being
manner,
able to
Mr. Rao.
address all the judgments.
Please.
If that is so, he should have given me the judgments and the note
Okay,
yesterday.
okay,
I
heard.
should have
This is
dealt
your
with it, my
judgment.
lord.
Okay.
I have
My
only.
lord, today there is an adverse resolution. My lord will kindly give me an
there is no
opportunity
adverse
to deal with
resolution.
his judgment.
He's again misleading the resolution.
Very well. Very well. Heard.
Stay cannot continue. It's their judgment which it says.
My lord, my judgment is different on facts because factually that particular judgment.
Okay, I have heard it. I have heard it.
Their own judgment says something.
My lord will kindly keep it on a different date. I will reply to the note and the judgment.
Very well. Respondent plaintiff. No, this matter appears under the heading of we mentioned. Learned counsel.
No, Miller, it's
appearing-
for hearing. For hearing, yes.
For
Yes,
hearing.
Miller. Fixed for hearing.
The matter is কি বললাম? Under the heading of hearing. Full stop. It appears that the incident matter is fixed for hearing after mentioning the same.
Right.
Full stop. Next paragraph. The plaintiff opposite party appears before this court and submits that the trial has already been started in the civil suit. If the said suit be stayed by the direction of this court dated 23rd/9/2024, the plaintiff shall suffer remains. Full stop. Mr. Das, learned counsel appearing on behalf of the petitioner submits that the matter can be disposed of in very early dates. Full stop. When the suit was filed?
2019.
2019.
PS1 of 2019.
19.
It is at the stage of cross-examination of the plaintiff's witness.
Okay.
And there is already an order for expeditious disposal of this suit, Miller, passed by Justice Sugato Mojumdar, on 23rd August 2023. This was not disclosed to your lordship.
It appears that the suit is pending since 2019. And after completion of all formalities, the suit has appeared in the stage of peremptory hearing. Full stop. It further appears that there are a direction of a coordinate bench of this court for speedy disposal.
Millard, this is the order, Millard. May I hand up?
Speedy disposal of the
Yes, second last page. if your
speedy
lordship-
disposal of the instant suit.
On
By
their
order
application, it
dated
was
by
passed.
22/8/2023 in CO number 48 of 2023. Full stop. Next paragraph. The issue which is pending before this revisional court to determine whether the trial court should act suo motu regarding impounding of two documents already marked as X1 and X2 for identification. Full stop. There are several conflicting decisions regarding suo motu action of the trial court in this matter. However, as it appears that the matter is quite ready for hearing, and the opposite party is also ready to contest the CO by filing affidavit in opposition. So the leave is granted to the OP to file affidavit in opposition. Let the matter be fixed for hearing on 5th of November 2024. Full stop.
My lord, may kindly keep it on that week, but on 8th, my lord.
8.
Millard, maybe the
It is
next
a
week
Friday.
after that. Maybe the next week after that, Millard.
Any day.
Millard, any date, the stay should be vacated, Millard.
That
Any
is
day,
the
Lordship.
severed issue. When the data matter can be heard.
Any date, Millard, after 9th that week, Millard, any date. Which is
Okay,
commensurate to your lordship.
11th of November 2020.
Much obliged, my lord.
Considering the fact that the trial is pending before the learned trial court, trial of the peremptory hearing of the suit is pending before the peremptory hearing of the suit is
My lord, it is for cross-examination, my lord.
learned,
Only one day.
that is within peremptory hearing.
That is peremptory hearing.
Keep on. Is pending before the learned civil judge concerned. I think it necessary by virtue of direction of the coordinate bench of this court in CO 48 of 2023 to modify my order passed on 23/9/2024.
My lord, will kindly not grant, remove
Order
the
of
stay, my lord.
stay.
It be
Order of
factually
stay
different. My lord, I am not
passed
able to.
on 23rd of 9/2024 is hereby modified and vacated. The trial court is at ease to proceed with this matter.
I'm deeply obliged.
My lord, today I am today.
There was a
taking-
direction, your lordship, for them
My
to
lord,
serve
today
us
I am
by register-
personally, I could not attend, my
petition.
lord.
Let them
My
serve
lord-
by registered port the petition, Millard.
You have
Because-
received it?
No, I have received, Millard, the scanned copy. And it is illegible. I request Mr. Dash to kindly tell his advocate on record to give us by registered post the petition. That was the lordship's order. Till date, it has not been complied.
Okay, very.
The lordship will find it from your lordship's order. But I request, there's no need for it to be recorded as in an order. I'm sure Mr. Dash will help me out with this.
Next.
I'm deeply obliged.
For correction.
Obliged.
Page number 9. Paragraph? Yes.
The amount of expenditure of treatment, rupees 7,60,247 instead of interest of 7,16,240.
It would be 7,16,000.
And the last line, 3,16,000.
Not 60, but 16. Okay. Then the all calculation would be corrected then.
Yes, sir.
Hmm. Okay, you read paragraph, page 13?
Page number 9.
No, page number 13.
Yes.
Third line, 3,16,000. That is correct. Okay, then the entire correction is not required. Very well, please take down. This matter appears under the heading of correction in the order dated 1st of October 2024, page 9, at paragraph 2. In the third line, the sum would be written as 7,16,247 instead of 7,60,247. 7,16,000 হবে, 7,60,000 জায়গায়, ঠিক আছে? At the next paragraph, at the same paragraph, the in the last line, the sum should be correctly read as 3,16,247 instead of 3,60,247. Okay, remaining portion of the order will remain. Next. Okay. This matter appears for correction in the order dated 1st October 2024 at page 3, last line. The year should be written as 2024 instead of 2023. Next.
In this case, line correction is there, Lordship. May I should hand over to the Lordship rectifying the same.
Give me the copy.
First of all, Lordship, who is appearing for the petition, name is not there, Lordship. Madhusri Dotto.
Petitioner is appearing Prosenjit Das.
Lordship, advocate's name, Lordship.
Yes, advocate's name.
Who appears, Lordship? Madhusri Dotto is appearing, Lordship. But
Joydeep Kanto Bhomik,
inadvertently, it appears that
Devi Sarkar, Jasmine Hogg, Nipa Das, they are not appearing.
No, Lordship.
Who appearing?
Madhusri Dotto and me, Lordship.
And Vikas Singh.
Yes, Lordship.
You both appearing.
Yes, Lordship.
And for the state, everything is incorrect.
No, Lordship, that is the correct.
That is correct.
Yes, Lordship.
OP's name is also correct.
Yes, Lordship.
Very well.
And
Now,
Lordship, paragraph number 2, Lordship, sixth line, Lordship, the spelling, Lordship,
okay.
muscular dystrophy. Instead of, Lordship, a muscular dystrophy. And Lordship, paragraph number 3.
Just wait. Let me see. Let me see. MASCULAR,
Yes,
not T.
not T, Lordship.
Dystrophy, DYSTROPHY.
Yes,
It is correct.
yes.
Okay. And
paragraph number 3, Lordship, line number 4, Lordship. He paid or transfer, Lordship. He actually he
F
paid
is
for
missing.
or transfer. Or is not.
F is missing.
F is missing, Lordship.
Yes.
And
In page, in. Yes,
and Lordship, paragraph number 2, Lordship. This is
what, page,
page 2, Lordship.
page 2, paragraph number 3.
Yes, Lordship. No, paragraph number 2, Lordship. Line
Paragraph-
number 7.
Line number 6. Okay, I understand.
And Lordship, Jalpaiguri and Baharampur spelling also mistake, Lordship. Type of
Jalpaiguri. No, in page 2, paragraph number 2,
Yes.
paragraph number 2. Paragraph number 2, which line you are mentioning?
Lordship, so he prayed for transfer, Lordship. He prayed or transferred.
That is right. Then thereafter,
Thereafter, Lordship, this is this was
in
wrongly typed.
in
This is-
page, in number, line number. What is the line? There is no such line at page 7. Spelling of Behrampur would be Berhampur.
Yes, Lordship.
Berhampur.
P-O-R-E. P-O-R-E.
Yes. PUR has been written.
Yes, Lordship.
Yes. Anything?
And Lordship, Jalpaiguri also, Lordship.
Jalpaiguri.
Yes, Lordship.
Piguri.
P-O-R-I.
GURI is there?
No, Lordship. Spelling only, Lordship. Paragraph number 9, Lordship.
Paragraph number 9.
Page number 4, Lordship. Jalpaiguri.
Okay.
And Lordship, paragraph number 8, Lordship. Line number 9, Lordship.
Where is paragraph number 8? Page?
Page 3, Lordship.
Page 3, paragraph number 8. Where is the paragraph number 8? There is no such paragraph 8.
No, Lordship. Paragraph
So
number-
you want the Jalpaiguri spelling?
Yes, Lordship. And paragraph number, page number 3, Lordship. Paragraph number 2, Lordship. Sierra number mentioned 762 of 2009, Lordship. It should be, Lordship, 2019, Lordship.
2019.
Yes, Lordship.
Okay. That's all.
Yes, Lordship.
Please take down. This matter appears for correction in order dated 1/10/2024. The learned counsel represented petitioner, learned counsels represented the petitioner was erroneously mentioned the name of the learned counsel shall be omitted and at their place, Mrs. Madhusri Dotto and Vikas Singh would be written. Next paragraph. At page 2, the name of the disease should be correctly read as MUSCULAR instead of MUSTCULAR. At the second paragraph, at page 2, second paragraph, in line number 4, after the term prayed, the term for should be written at place of or. Full stop.
Dear Lordship.
In page number 3, second paragraph, third line from below third line, top. But 1, 2, 3, 4, 5, 6, 7, 8. Ninth line, second paragraph. At page 3, in the second paragraph, in the ninth line, the CRR number should be correctly read as 362 of 2019 instead of 2009. Instead of 2009. Next paragraph. In the said judgment, in the said order, the spelling of Bahrampur spelling of Behrampur, BEHARAMPUR, should be correctly read as Berhampur, BERHAMPORE. Okay. Next para. At the fourth page, and the second line, Jalpaiguri, JALPAIGUIR, but in should be read as JALPAIGUIGURI.
Lordship, kindly page number 2, Lordship, last word, Lordship.
Jalpaiguri.
Page number 2, Lordship.
Page number 2.
First prayer, Lordship. Last word, Lordship. This is Lordship.
Okay. And at page number 2, last word of the first paragraph should be read as disease.
Yes, sir.
DEDISEAS, disease instead of disease. Disease. DECAS. Okay. The office is directed to do the corrections in the order itself. Remaining portion of the order.
Grateful, Lordship.
Next,
My application for extension of interim order, my lord. Filed my affidavit of-
Lordship, I am for the opposite party number 2 in this matter.
My lord, filed within time. Milord. একটা ক্রেডিট ফটো দিও না আমাকে।
Plan number?
Plan 2 of 2024. Hey. Milord, entry order was expiring on 31st of July 2024. I filed the application on 30th July 2024. এখনই।
When the order of stay was granted, interim order,
Initially granted by Justice Rao Milord on
21st of May.
yes, Milord.
Please take down,
Extended by Justice Mukherjee Milord.
please take down. Affidavit of service filed on behalf of the petitioner is taken on record. আচ্ছা, ওই প্রথম যে অর্ডারটা করেছে, first, সেই অর্ডারটা বলবে, সেই অর্ডারটা লিখবে যে petitioner appears virtually.
Or state prison, Milord.
Lordship, OP number 2 name may be recorded, Lordship.
Okay. এটা না কি বললাম? File by the petitioner is taken on record. State is represented.
Yes.
OP is private opposite party is represented through learned advocate. What is your name?
Abhilash Mittal.
Avilas Mittal. Virtual. This is an application for extension of interim order. Grant 2 kochu. Will grant 2 head. It appears that the interim order was passed by this court on 21st of May 2024. Thereafter, it was extended time to time. It appears that the parties are ready to do this matter. Accordingly, the matter will be fixed for hearing in the next available circuit. Full stop. Considering the submission of the learned counsel for the petitioner, grant 2 of 2024 is disposed of with a direction that the interim order passed by this court on the earlier occasion is further extended till 14th of November 2024 or until further order, whichever is earlier.
Much obliged.
What are the developments? Next.
I'm for the petitioner in item number 8, Lordship.
Lord, I am for the state, my lord. Case diary cannot be
Lordship, this is the affidavit.
collected, my lord.
Lordship. There is an application for extension of interim order, Lordship.
Who is for the opposite party?
And for the opposite party number 2.
Private opposite party number 2.
Yes, your Lordship.
But 8 and 9, both the similar matters.
Similar matter.
Similar
Lordship.
matter.
8 and 9.
Can be
Yes.
taken.
It came up for a hearing the day before yesterday.
This is the affidavit of service on my.
Just wait.
Okay.
So today is fixed for extension of interim order.
Lordship.
For
Please to observe that it can be taken up for final hearing day before yesterday.
Okay, whether you are ready in this matter?
I'm ready.
I am ready.
Yes,
So-
what is the matter?
Yes. May I proceed? Lordship?
No, what is the not, today is the last day. I have to pass the judgment then.
Yes, Lordship. If possible, and if they are ready with affidavit in opposition, then also I am ready with my.
I'll
yes.
be arguing my case straight away.
Straight down. Yes, what is the matter about?
Lordship, my mother purchased the land.
Very well.
The deed is annexed here at page number 12, Lordship. Now, the registration was given, that is 2% were the previous owner of this land. Now, my mother purchased this land. Subsequently, this opposite party number 2 made a police complaint stating that my mother made a forgery in the said deed. The matter is that, Lordship, in this deed, I'm not a party. However, they have entangled me in this case because after getting the registration, that is after the change of the title of this land, my mother gifted some portion from that land. However, Lordship, they have never challenged the title of this land by way of any cancellation of deed. This is the first thing. Secondly, Lordship, the person who was present at the time of registration has never challenged his signature during his lifetime. His son, after the demise of that person, challenged that signature. Even if we consider the signature is forged, then also I cannot be make a party in this case because, Lordship,
There is the police case number 51 of 2022.
Yes, your lord.
Yes, my lord.
Lordship,
Yes, your lord.
51 of 2022.
Yes.
because, Lordship, the day when the registration was taken place, I was of 16 years of age. Secondly, my lord, in the deed, I have annexed the photocopy of the deed. Nowhere in the deed you shall get a single signature of mine, Lordship. This is the second thing, Lordship. Third thing, when a deed has never been challenged, my title cannot be in question. So, rightfully,
In the criminal case, your title is not there. Criminal case, your title is not in the dispute or not criminal case.
in criminal case, they have
The-
entangled me.
Yes,
On the
criminal
case-
case, whether there is in criminality or not, the title
There is no
there.
criminality at all because, Lordship, even if we consider the signature has been forged, even if we, for the sake of argument, if we consider, though it is not a forged signature.
Now, what is the
Lordship.
stage of this case? What is the stage of the investigation?
My lord, charge sheet submitted, my lord.
Charge
My
sheet
lord, charge
submitted.
sheet charge sheet not submitted, my lord. Actually, my lord, they have not produced the document and we cannot verify till date, my lord. The question document not yet been recovered from the persons. And we cannot verify the
So
signature
you have
of
only challenged the FIR.
Yes, and my question is very specific, Lordship.
investigation still in progress, your lordship. Documents, question documents are yet to be recovered from the persons.
No,
And
look,
it-
your title, whether your title is good or bad, that is not the look into by the criminal court.
Yes,
Okay.
yes.
Lordship.
So you may have the good title, you
Yes.
may have the bad
Maybe.
title.
It's
That
It's a
is
matter
no
of
issue,
absolutely matter of trial, your lordship. They
That is no issue of the criminal case also.
But
yes,
that
yes.
is not-
But one thing, Lordship. The matter is that
No,
the
the investigation is going on.
Yes,
So how can we ascertain the matter without the investigation?
Yes.
the thing is that in the
Let
same
the,
deed,
let the investigation be completed.
let me finish. Let me finish. The thing is that two things, Lordship. I was not a party in the said deed. Even on that date, even if we consider the signature
So
is
it
forged,
may appear after investigation that they may file the FRT against you.
Yes.
That may be done.
Is it yes?
that may be done.
After
but the thing
completion
is-
of
Why you are
investigation,
here?
if we find up till during investigation, if we find
You are not the party.
Yes.
You have no criminality. You have no chance to
Yes.
include in the matter.
Yes.
Get the
But
FRT.
I have to go before the criminal court day by day. and
No,
the
you
matter is
don't
of-
have to go now. You have to
till
just submit the.
conclusion of the investigation,
Let the
your appearance is
investigation
not
complete.
required.
Let them come with the affidavit in opposition, then I shall file my.
No. I don't think.
Not affidavit. Not
Yes, yes.
affidavit is
Now,
not required.
We are
another
not
thing, Lordship.
We did not file any affidavit in opposition.
Another thing.
This is the
Lordship.
premature stage
Yes.
of investigation, my lord. Let the document, question document yet to be recovered from their position and we have to verify those.
Another thing here also, Lordship. The date when the alleged incident took place, I was a minor. I was of 16 years of age, Lordship. So, in a FIR, when the forgery is in question, no direct allegation of forgery has been made in the said FIR against me, Lordship. Kindly go through the FIR.
I have already read out the FIR.
Yes, Lordship. So, therefore, the entire allegation is against my mother, not against me.
No,
So-
why the revisional court or passing court to decide? Let the investigation authority decide. the
Against
matter.
my mother, not me, because I was not a party in the.
Very well. Let
Yes.
them decide the issue.
Yes.
Even after the, I
Let
am
them
not
decide the
challenging.
You may be discharged from the
Yes.
case after completion of investigation.
What is the purpose of the discharge of this matter?
This
right
time,
now?
at this time, at this
At
stage,
this
your
time,
lord.
this court has not power to assess all your documents like that.
Yes.
Lordship.
They are the authority to assess your document and assess your evidence.
You
of-
produce
they may
those
call
documents
you-
before us.
They may call
You can produce
whether
those
you are
documents
there or
before
not.
us.
But another thing, Lordship.
The only direction you can have that the no coercive action can be taken against you.
Yes, that can be done. No coercive
that can
action.
be
That can be,
Yes,
that can be, your lordship, that
Yes,
can
what
be.
it is.
And if they assist with the investigation, That can be done. Along with, my lord, the document
Yes,
may
but
be
he has
produced
the
before
an
the.
opposite party, who is
Yes,
the de facto complainant.
yes.
I'll just take few minutes. Actually, the father of the respondent number 2 of the CRR number 271 and the grandfather of the opposite party number 2 of the CRR 270. He purchased landed property in the year 1956 by a registered deed of gift. He was a resident of Madari Hat under Alipurduar district and he purchased the property in Dadri. Thereafter, in the year 1984, he settled 20 out of 75 polls. He settled 22 polls in favor of the respondent number 2 of the CRR 271 and the father of the respondent number 2 of the CRR 270. And out of 22 polls, they sold out 14.4 polls to different persons over time. And remaining 75 polls were left in the care and custody of the mother of this petitioner. And since there was a resident of Tari Hat, she was the mother of this petitioner was elder sister. So in good faith, it was left to the care and custody.
Okay, let
So
the matter
it's
be,
clearly a civil
let
nature case, Lordship.
let the matter be decided by the authority concerned. Investigating authority concerned.
Grateful, your lordship.
Okay.
Till then, there shall be
Okay.
no
That-
coercive action.
Very well.
Yes.
Please take.
My lord, one order may be passed, my lord, along with the to produce the documents.
Yes, to
Before-
cooperate with
before-
the investigating agent.
Yes. Otherwise, they will not produce the documents.
Okay. এটা লিখবে ছোট্ট করে লিখে দিচ্ছি হ্যাঁ? The instant CRR has been preferred for quashing Darjeeling Sodor Police Station case number 51 of 2022 dated 2/5/2022 under section 420, 406, 468 stroke 34 of IPC. Full stop. The present petitioner submits that he has been arraigned as an accused in the above mentioned police case. The allegation in the FIR appears to be false and concocted. The present petitioner was minor at the date of alleged execution of the deed. Moreover, no materials is there against the present petitioner to involve him in the criminal proceeding. So he prayed for quashing. Full stop. Learned counsel appearing on behalf of the state submits that the investigation is going on at this juncture. Without conclusion of investigation, it is not possible to justify the criminality of the present petitioner in this matter. The opposite party has raised strong objection and submitted that there are specific involvement of the present petitioner with the alleged offence. Full stop. Having heard the learned counsel for the parties, also considering the fact that the matter is under investigation of the police. So at this juncture, without the investigation is concluded, the fact of the FIR cannot be justified. Whether, full stop, whether the appellant or whether the petitioner was actually involved in the alleged offence or not can only be ascertained after thorough investigation of the police. Accordingly, I think it necessary to dispose of the instant CRR as premature. Full stop. The instant CRR is disposed of. Full stop. The petitioner is directed to cooperate the investigation of this matter.
And produce the documents, madam.
Cooperate the investigation of this matter as required by the IO time to time. Full
Yes.
stop. On that score, the investigating agency shall not take any coercive action against the present petitioner.
However, Lordship, in this, at this juncture, I have to say one thing, Lordship. I am referring one judgment of the Honorable Supreme Court of AIR 1965, Supreme Court 1251.
For what?
Here also, it has been clearly mentioned that if I am an accused person, I cannot be compelled to produce such evidence which may incriminate me, Lordship, like deed of
No, no,
This is
that
the
is not the
situation,
issue
Your
here.
Lord. Yes,
That is
yes.
not the issue.
So,
Separate
the
issue.
question document
apart from
belongs
that,
to them.
You cannot be liable to pay the document on your possession.
yes,
If it is not either actually required for the purpose of a criminal investigation.
Yes.
Okay,
Yes.
so you should not be given direction to produce such document to prove your criminality.
Lordship.
That is the
Lordship,
issue.
Lordship.
And separate issue is there to that
Lordship.
effect. Without approval or like that,
Yes.
that is not the possible. So this is the criminal measure, this is the
So
otherwise.
till then, no course of action.
Till then, no course of action. Huh? No,
Yes.
disposed of.
Well, a document may be produced.
And
I have already passed the order.
CRR 271 complaint case was filed
Yes.
in that case,
Next matter.
directly in the court of the learned magistrate. And in that complaint case, an application was made under section 91 of the CRPC seeking direction upon the petitioner to produce the document. And the learned court was pleased to direct
Oh,
the
nine, sorry,
petitioner to produce the document. And she has made a clearance to this court for question.
This is also a case of
Same,
posting.
Same
same,
case,
same,
Lordship,
same.
relating to same document,
Same fact.
same fact, Lordship.
No, oh, whether it is a criminal, it is a CRR.
CRR.
CRR, Lordship,
A
under
complaint case.
200 CRPC, they have filed it against me and my mother.
About the same issue.
Yes, about the same.
There were two brothers to whom the land was taken, in favor of whom the land was taken.
Please take down. The instance here it is preferred for quashing a complaint, criminal complaint, criminal complaint case,
Against this particular petitioner.
complaint case against the present petitioner being CR case number 10 of 2022 under section 34, under section 406, 420, 465, 468, 471, 120B of IPC, pending before the learned judicial magistrate Darjeeling. It appears to me that the present petitioners are arrayed as an accused person before the learned jurisdictional magistrate. It is the submission of the learned. It is the submission of learned counsel for the petitioner that the petition of complaint is false and fictitious. The alleged offense made in the petition of complaint has never been conducted by the present petitioner, as he was a minor at the time of execution of the alleged deed of sale.
And I was not a party in the said deed also, Lordship.
He further submitted that he was not a party to the said deed. It appears that the learned jurisdictional magistrate is insisting over this matter, and the present petitioner has already appeared before the
Yes,
learned
yes,
magistrate and obtained an order of bail.
yes, Lordship. I am appearing on every date, Lordship.
Okay. Considering the situation, I find no justification to entertain the instant CRR as the matter is going on smoothly before the learned jurisdictional magistrate. However, the jurisdictional magistrate shall conclude the trial of this matter as early as possible, more preferably within 6 months from the date of passing of the trial.
Until then, no course of action against me, Lordship.
No, you have got only bail.
Yes.
You have already received bail.
Despite that, Lordship,
But in
so
this,
if I,
that be an order to comply the order of the learned magistrate in which she has been directed to produce the
Eight,
impugned document.
No, no. That is not the,
That's the issue of
that is
the.
not the issue here.
No,
Yes,
note our,
very-
note
that
our
is
appearance
something-
and objection, my lord. Note our appearance and objection.
Yes. You will know. Order. The learned magistrate shall dispose of the case according to the procedure of law, and the parties are at liberty to approach before the learned magistrate and conclude the matter as directed by this court within 6 weeks, within 6 months, positive. The opposite party appears and there is strong objection.
Obliged, Lordship.
Possible.
Next,
Item number 10.
Yes. Then, my lord, in this case, my lord, I am appearing for the state, my lord. Case diary is not available in this case, my lord, but as per the record, my lord, I have seen, it is a case of 498A. And, my lord,
Milord, case diary may not be also required.
sister-in-law, against sister-in-law, quashing was filed, 482 was filed by CRR number 125 by 2023. That was quashed, and there, that in that order, my lord, all findings are there.
Even the CD
Here
was.
Here,
Your lordship will kindly hear me among VC, my lord. Am I audible, my lord?
yes,
My lord. My lord, in this application, the lady may be out of grudge or something, has roped in the entire family. The place of occurrence was Singapore and Siliguri, both S. And they have roped in the father-in-law, mother-in-law, sister-in-law, those who happen to stay at Madras, Chennai. And like your lordship, if I am permitted to say, like medical tourism, she has taken a legal tourism, came to Siliguri and lodged a complaint, where all her allegations are in Singapore and maybe a part of it with the husband in the Siliguri. No investigation was done at Chennai. The father-in-law and mother-in-law do not stay with her. They stay separately in a separate mess. She came to marry, went within 10 days to the place, before that had honeymoon, went hither and thither and went to Singapore and made a complaint coming to Siliguri very conveniently, and the woman police station has made a case out of it, and very strangely enough, the police authorities have parroted her words in the CD, in the charge sheet, and your lordship will kindly see matter which was quashed against the in-law. Your lordship kindly comes to that. Page number 31. My lord
why
kindly
the CD is there? Why the CD is there?
my lord, case diary is not available, my lord.
But there is different allegations against the in-laws in the FIR.
Yes,
Your lordship
Can I
kindly
justify without the CD?
yes.
lordship kindly sees 31. CD was perused. Nothing was found by the
No, they may say peruse the CD in respect of the sister-in-law.
Sister-in-law. Here is the father-in-law and mother-in-law.
Mother-in-law?
For a moment. My lord kindly comes to page. I'll satisfy your lordship. Kindly comes to page 32, my lord. 32, my lord. Lord comes to page 32, gets page 32.
Yes.
Milord, 10 days after marriage, she went to Singapore with her husband, and 2 months thereafter, her in-laws came to Singapore. She was subjected to mental torture over there. She was forced to carry out day-to-day household work. None of the family members extended their help. In the month of March 2018, she came back to Siliguri with a mind to spend some days with her parents, but in-laws started taunting her and put her under pressure to come to Chennai. They were in Chennai, called the daughter-in-law that you come to Chennai, that is pressurizing. The in-laws were instrumental in creating a rift between herself and her husband in the month of November during the Diwali when she came to Chennai. She was asked to do all the household work. The informant took a job in telesales company which was not liked by her in-laws.
She was abused, even and threatened with dire consequences. Then Millard kindly comes to page 34. Millard kindly comes to page 34. There is hardly, Lordship gets page 34. Lordship gets page 34.
Yes, this is the observation of a coordinate bench.
Yes, coordinate bench. Lordship kindly sees. Just 34
Oh,
one.
no. I have to ascertain by the CD. Otherwise, I cannot pass any order.
Yes.
Lordship kindly sees for a moment, Lordship. Kindly allows me. Thereafter, your Lordship.
Say, if there is CD, I can consider your submission. Otherwise, how can I?
Petitioner, petitioner, the mother-in-law and mother-in-law.
It is my carriage of proceedings. Just a moment, Mr. Counsel. My lord, is it the luxury of the state that will not carry out the order of this honorable court? Lordship kindly sees your lordship's order on the last date. Give the order.
Yes, I have directed to produce the
Yes,
CD.
yes.
Lordship kindly sees. If this be the conduct of the state, then at no point of time we can make a hearing. Yesterday also it was stated to bring the CD. Last day also Lordship directed. Now Lordship, if they don't bring the CD and we have to suffer for that, the old lady and the person is dying every day.
No, I understand how you are suffering for the pendency of the matter.
Not when it
Whether you are called by the investigating agency.
No, Your
Let the matter be decided fairly. Otherwise, how can I decide the matter without the observation of the another coordinate bench without producing the CD?
Lord, I'm not asking your lordship to decide. See the conduct of the state.
I understand. I am passing the
Commissioner of police may be directed to bring the CD on the next
So
day.
when it would be possible for to bring a CD?
My lord,
Next
this is the last date, your lordship.
I know this is the last day.
Before puja vacation, your lordship. After puja vacation, my lord, we will produce the case diary.
So what is about the investigation?
Investigation complete, my lord. Charge sheet submitted.
Charge sheet submitted?
Yes.
Yes, the charge sheet has been annexed here. Your lordship can very well decide it
Charge
here.
sheet annexed with the petition, your lordship. Charge sheet
Against the petitioner?
Yes, petition annexed with the petition. Charge sheet is there, my lord. Charge sheet submitted, my lord, on.
Have you got the copy?
Yes.
Whether they have got the copy?
Yes.
That
We
is
have-
not. That case,
Whether copy has been served upon them, the accused persons?
that maybe they can.
Whether the
they can
copy has been completed? That is
207,
I say
207.
the 164 all police papers.
207 compliant.
207 copy whether complied. If you produce it, that I can verify it.
Yes.
Not required to file the
Case diary.
there is the CD or everything. 207 complied.
Let me check. Just a second.
207 perhaps not compliant.
Then how can I proceed?
We have got the certified copy of the.
Only CD, only charge sheet is.
Certified copy of the order, all order sheets are there, my lord, and
No,
the
no.
charge sheet is there.
No, not necessary.
Yes, yes.
I want the police papers.
Yes, yes. The 162 statements, 164 statement, medical, whatever. may.
Lordship, for a moment, my lord, kindly comes to page 35. For a moment, for my satisfaction, my lord.
Yes.
Yes, my lord, kindly sees page 35, 34, my lord.
Yes.
My lord, kindly sees there is hardly any statement in the FIR or any evidence in the case diary collected during investigation to suggest that the petitioner was instrumental to harass the de facto complainant or to coerce her parents to meet any unlawful demand. There is no allegation that the petitioner overtried to goad the victim to commit suicide or did any act to cause grave injury or danger to her life or health. There is nothing to hold. She demanded dowry. Therefore, in my humble opinion, in the absence of evidence against the petitioner, she should not be made to face the trial. The charge sheet should be quashed qua petitioner, abuse of the process of law.
That was against
That
the
is the
sister-in-law.
There is a sister-in-law.
You have, the learned counsel for the state, do you have any evidence now, right now, to say, suggest anything against the father-in-law, mother-in-law? FIR makes it very clear.
That is why we are asking for time and produce the case diary.
No. If you can produce the police papers,
Yes.
207 also to decide the matter. I am fixing a specific date. Please take down. The CD is not produced in spite of direction of this court. Accordingly, accordingly, investigating agency is directed. State is directed to produce the CD positively on 6th of November 2024.
Good.
Let the matter fixed on 6th of November for further hearing of this matter. No, for hearing of this matter. Further prolongation.
Present personally,
Yes. Petitioner represented. নামগুলো নিয়ে নেবে।
my lord, I would be present personally.
It is not placed.
Duty of land.
On further together for hearing. No. নামগুলো CD is not placed. Only আর কিছু না।
I'm for the revisionist. It's a very small matter, Lordship, involving a very small point. Lordship, this is a NDPS case. Certain contraband articles were seized from the possession allegedly from this petitioner. And after investigation, the police submitted charge sheet.
Yes.
The charge sheet was submitted, Lordship. May I take your Lordship to the civil list first, that is page 26. And it's a P2. Before I go to the niceties, Lordship, I would like to place that, and I would like to submit that a case of NDPS, Lordship knows that better than me and anybody here, that to fix or specify the quantum, whether it is a small quantity or commercial quantity, the weight of the contraband article has to be taken into consideration. In a case of manufactured drug, the entire drug goes, Lordship knows. In a case of, suppose, Fencidil, if 100 ml Fencidil is there and 5 ml codeine is there, it has to be considered as 100 ml codeine.
Yes.
Entire it goes. Even taking that presumption here, what are the articles?
So what order you have challenged?
I have challenged the charge sheet, Lordship.
You have challenged the charge sheet?
Charge sheet under 21C NDPS Act. Another statutory bail application was made, which was been turned down by the honorable learned trial judge.
Today, last day, how can I hear this matter?
I'm not going for that trial judge portion. I'm only praying before Lordship to consider this part. Page 26, para 5, description of seized articles.
Yes.
There are 2 articles seized.
Yes.
One is 36 strips of nitrosum 10 tablets each. Contains 10 number of tablets in per strip. And another is 576 of spasmoproxifon plus capsule containing 288 numbers of capsule total. Got it, Lordship?
Yes.
Now my condition is, Lordship, first, if Lordship has the NDPS book with the Lordship. Lordship says, I have marked this my copy.
Narcotic drug NDPS.
Lordship, I have marked. First, nitrosum 10 tablets. Commercial quantity is 500 grams.
Yes.
Another, Lordship, another flap is there, pink color. This that is tramadol. That is 250 grams is commercial quantity.
Yes.
Now, why I am saying so? As because, kindly see, Lordship, page 27 of my petition. What is Lordship?
Yes.
Plasmoproximum plus capsule, which has been seized. What are the salt composition? Dicyclomine 10 mg, paracetamol 325 mg, and tramadol 50 mg. So I cannot take tramadol 50 mg only because it is the entire which goes. So total it comes, Lordships, I have made a calculation in page 16 of my petition, para 1.
Page 16.
16, 1-6. Para 1.
Yes.
Lordship says, one spasmoproximon plus capsule weight is dicyclomine 10 mg, paracetamol 325 mg plus tramadol 50 mg is total 385 milligram, one capsule. Now total weight is 576 number of capsules here as per the list. So it comes 2,21,760 milligram, that is 221.76 gram.
Yes.
Now Lordship has seen the tramadol, and I am talking about the entire composition, Lordship. But the tramadol is 250 gram for commercial quantity. So the entire, if we take the entire, is below commercial quantity. Now, nitrosamine 10 tablet, 10 milligram per tablet, and total weight is 360 numbers of nitrosamine tablet, that is 3,600 milligram. That is converted to 3.6 gram. So total weight is 2.25.36 gram. That is under the intermediate quantity of that is under commercial quantity. So if it is under commercial quantity, 21B comes, not 21C. Charge has been given in 21C, and then 37 is not applicable.
Where is the charge sheet? 21C.
21C.
Yes.
21C is
And as well as the Caesar list, my lord.
21C. How 21C? It is below commercial quantity.
Yes, we
It will be 21B. And
I was just
21
going
because
through the
that-
annexures of. I was just going to the page number 16, my lord. I was just calculating, my lord, and upon the Caesar list, my lord, exactly the total weight comes at around 225.36 grams.
So it's
Whereas
below
it
250
should have been given under 21B.
B instead of 21C. So you decide the matter
Lordship,
and file the supplementary charge sheet.
Or if Lordship can
No, no,
just direct that it will be a case under 21B,
no,
not 21C.
no, that would be not proper. They have to come with
yes,
the
yes, Lordship.
specific.
Then the observation may be there in the
Yes,
order.
yes.
That is the Caesar list, which
Yes.
is there annexed in that copy also, and the last portion is the charge sheet.
Please take down.
फिर उसके बाद तो हो जाएगा आफ्टर कैलकुलेटिंग यहाँ तो बिल नहीं देगा
the instant CRR has been preferred against order dated 25/6/2024 and 27/6/2024, passed by learned special judge under NDPS Act, Alipurduar, in connection with NDPS case number 9 of 2023, arising out of Jayaguan, Joygaon Police Station case number 289 of 2023, dated 18/12/2023, for the alleged offence punishable under section 21 within bracket C stroke 29 of Narcotic Drugs and Psychotropic Substance Act 1985. The brief submission of the learned counsel for the petitioner is that the petitioner was apprehended with 36 strip of
Nitrosum 10. Nitrosum 10. Page 30.
Page 4. Page 4.
Oh,
Apprehended with page 4, 1 and 2. Okay. কি বললাম? Petitioner was apprehended in connection with this case, and it has been alleged by the prosecution agency that from his possession the following articles, following contrabands were seized as follows. Bole 1, 2, page 4. 1, 2 করা আছে, তুলে দাও। আছে। It is the further submission of the learned counsel for the petitioner that the police had submitted the charge sheet against the present petitioner after conclusion in investigation under section 21C stroke 29 of NDPS Act. He submits that the contraband which was seized from the possession of the petitioner is below the commercial quantity. So the charge sheet should be filed under section 21 within bracket B stroke 29 of NDPS Act. Full stop. For the learned advocate for the state, peruse the seizure list. It appears from the seizure list that the submission of recovery, what is that? Give me your book.
Lordship, how would you go? All the way with you. Oh. Lordship here. Who put the
Yes, you know, platforms. Flapta niye nebe ta?
In my petition, Lordship, page 27 and page 30, we have filed the short composition of the particulars.
Yes. 27 and 30.
Lordship. 27 is spasmoproximon plus capsule, and 30 is that nitrosan in short composition.
বলুন বলুন। Submission of recovery. Submission and fact of recovery. Submission called a fact of recovery. Fact of recovery, as stated by the petitioner, has been substantiated in the seizure list dated 15/12/2023. Full stop. the salt composition of spasmo proxivon plus capsule. Item page 27. এই ক্যাপসুলটা না প্লাস ক্যাপসুল
It's in the top.
আছে প্লাস ক্যাপসুল is as follows. Item আছে 30 page 30. Salt composition of nitrosan 10 tablet includes এই কোনটা লিখবো না নাইট্রোজে পাম্প 10 mg আছে শুধু এইটুকু লিখবে হ্যাঁ বুঝতে পারছি you have made the calculation of composition in paragraph
In paragraph 1 of page 16.
16. The petitioner has calculated the weight of the contraband as follows. A ground number 1. Yes. Concluded. Calculated the weight contraband in ground number 1 of the instant CRR as follows. Of the instant CRR as follows. Page 16. So after calculation, the total weight of contraband comes to rupees 225.36 grams. Full stop. According to the schedule of NDPS Act, according to the schedule of contraband, schedule of psychotropic drugs and contraband article regarding its commercial quantity, the item number 221 contain nitrazepam, NITRAZEPAM. The commercial quantity is 500 gram. And in the said list, item number 238 is tramadol, TRAMADOL. Commercial quantity is 250 grams. Commercial quantity is 250 grams.
That's your one indulgence.
Tramadol,
Tramadol.
TRAMADOL. Yes.
Rashid, the last one, list, and 239 perhaps. Last one, I have marked.
231 লিখেছো 238 লিখেছো
Any mixture or preparation.
ZH করো ZH capital ZH হ্যাঁ 238 ZH থাকবে yes
The last one in the list where it is mentioned any mixture or preparation that of with or without any natural materials of any of the above drugs. So the paracetamol is there, but we have to take the entirety.
Yes.
Even taking the entirety does not come into commercial quantity.
লিখো in item number 239 of the said list it has been mentioned that with an inverted comma লিখো any mixture or preparation that of with or without a neutral material comma of any of the above drugs. Full stop. That means the neutral material which is not actually declared as contraband article has to be taken weight along with the contraband article. to consider the entire situation, it appears to me that the total weight of contraband is under the commercial quantity. Below the commercial quantity. Below the commercial quantity. কি বললাম? বলো। Contraband which was seized. Contraband which was seized from the possession of the present petitioner in connection with this case. তারপরে ওইটা হবে below the commercial quantity. Okay. Prima facie, next, it appears to me that the charge sheet submitted against the present petitioner under section 21C is not proper. Rather, it would be 21B of NDPS Act. Full stop. However, the matter has to be decided by the investigating agency. At this juncture, I think it necessary to dispose of the incident CRR with a direction to the concerned authority, stroke investigating agency to weigh the contraband article according to the law and submit the supplementary charge sheet if necessary according to the law.
Yes, my lord.
Grateful, Lordship.
City bank करते process करते उसको मत है तुझे back कर दे उसको भेज दे
ওইটা না দেখ ওটা আমাদের থাক আমাদের দিক এটা আমাদের yes next
I'm for the petitioner in item number 12, Lordship.
yes what is the matter?
Lordship, this petitioner purchased a plot of land.
Lordship, may I?
You are appearing?
I'm for the OP number 2, Lordship.
Yes.
Lordship, on last occasion, there was a direction to file opposition, affidavit in opposition, but for that we are awaiting an investigation report, which is yet to be submitted or served on the opposite party number 2. And that's
You
what
are the de facto complainant.
Yes, she is the de facto.
the de facto on the original complaint.
Lordship, kindly go through the last order, Lordship. It will be clear.
Lordship, some time is required in that respect for that report and also filing the affidavit in opposition.
Then Lordship, give a stay of the proceedings that is pending in the Lanet court below, because they are dragging the case from the very first day, Lordship. Let them come with the affidavit in opposition, till then there be a stay, Lordship.
But in Lordship, for filing that affidavit in opposition, we are awaiting the investigation report, and which has still not been submitted or served upon us.
Otherwise, Lordship, allow me to proceed with my case, Lordship. When I cited judgment, everything I have done on my part, Lordship.
Okay, there are some allegations against the complainant also.
Against the de facto complainant also,
Against the
Lordship.
de facto complainant.
Yes, Lordship, and they have not come here with the clean hands, Lordship.
Okay, I understand. So the affidavit in opposition required. Why you not ready with the affidavit in opposition?
Lordship, as I stated earlier, that we are awaiting an investigation report.
What investigation report you want?
Lordship, there is also, in respect of the original complaint, a contempt application is also pending, and where the respondent authority.
Contempt?
Yes, contempt.
Against the
What
police,
contempt?
not against me, Lordship.
Against the police, but we are awaiting that investigation report from the police, which is yet to be served.
No. Police, whatever may be the investigation is separate way.
But Lordship,
you are the opposite party of this CRR.
Yes.
some allegations is made against you,
Yes, yes, Your
you have to justify or you have to deny the allegations
Yes,
by
that's
filing
it.
the
But
affidavit.
Yes, Lordship, for filing that affidavit, I am actually, that investigative report is actually required.
No, no, investigation report is separate
To
issue,
clear
not
that
required.
allegations of me, I am actually in requirement of that report. Lordship, kindly allow me some
No, no,
time to file that.
investigation report,
Yes,
no, no.
sir.
This is,
That's
this
the-
submission cannot be accepted. You may have the time or may have the accommodation to file that, but this is not the submission. This is not the submission in the
the-
criminal
Lordship,
case.
If
You
I
are the
had,
complainant, you
Yes,
lodged a complaint, you know your case better,
Yes, Lordship.
okay, rather than the police officer or otherwise.
But-
You must have praise your case. Whatever maybe the police report is doing or not, that is the issue of the police.
Lord-
and
Lordship,
during the
in
investigation,
that
one
I
FIR has
am
been lodged by the
seeking some
police.
time, some liberty must be granted to us. Some extension of time to file that.
Yes, then
affidavit.
kind of
That can be
If-
no issue, so that
yes,
can.
give a stay and then.
So
come.
what do you want to stay?
Yes,
Why
Lordship.
you want the stay?
Then.
Let the investigation is going on.
Yes, then Lordship kindly allow me to proceed with my case, Lordship. I am
What
ready
case?
with my case.
How the case can be proceeded without the affidavit in opposition? Direction is already there.
Because they are, they have not come with the clean hands, and they have taken.
Let the affidavit is taken for that reason. Otherwise, it
And
cannot.
they are dragging the matter, Lordship, from the very first day, and every day they are stating
Very
that
well.
they
I
will
am
come
passing
with-
the order. Please take down. An accommodation short for on behalf of the opposite party number
One
two
thing, another one
to
indulgence,
file
Lordship.
affidavit in opposition. Yes,
One indulgence, Lordship.
yes.
They have not come with the affidavit, but I have a very small prayer, Lordship. Kindly come to page number 17, Lordship.
What?
This is an order passed by the learned trial court whereby I have been directed to produce original copy of the deed in question, Lordship.
Yes.
At present, Lordship, I lost my original deed. I want to hand over the certified copy of my deed, Lordship. I am ready with my certified copy of
Then
the
you
deed.
go to the court who has passed the direction. Why before this court?
But Lordship, for this reason also they are praying for they will come with affidavit in opposition, Lordship.
No,
So
go to the court. Go to the court. You go
We-
to the
we-
court with the prayer.
yes, we made the prayer.
You go to the
We
court with
made the prayer, Lordship.
Who
It has
got
been-
you to go to the prayer?
It has been given, Lordship. We made the prayer and it has been mentioned.
Okay, let the matter be decided by the court itself. Okay,
Lordship.
please take down. Okay, the said prayer was hotly contested. No, the said prayer was vehemently contested by the petitioner. Having heard the parties, it appears to me that the matter cannot be proceeded without the affidavit in opposition on behalf of the opposite party. Full stop. If the opposite party is reluctant to file the affidavit in opposition, then the matter can be taken up without the affidavit in opposition. The matter be fixed on 5th of November 2024 for hearing of this matter. The opposite party is directed to place the affidavit in opposition within the adjourned date. If the opposite party fails to file the affidavit in opposition on the adjourned date, the matter should be heard. Matter will be heard. Matter will be heard.
FRT has been filed, against the case they have referred. That FRT report.
Come with the affidavit.
That FRT report, we have.
Why is the FRT? If FRT is there, the document can be obtained from the court itself.
Document, it has not been collected, that was the affidavit of it.
Then you file the affidavit that the FRT has been paid. Your affidavit is sufficient. Why not filing the affidavit?
Affidavit, in the affidavit, I have to include that document only.
Not required to be included. That may be called for. What is the requirement? You only to state that in this case FRT has been filed. That is sufficient.
Till the Lordship, no coercive action be taken against me.
What is there is no such order.
This is the land lord, they are land grabber lord.
So let them come with the affidavit. They are praying.
Okay. When the date? When the date is 5th November. You बोलो ना बोलो. If they fail to file the affidavit, matter will be heard on behalf of the parties. Matter will be heard. Matter will be heard without the affidavit. Next.
For the state lodge. My lord, in this matter, we have filed one grant application, my lord.
Grant for what?
Grant for, my lord, suspension of the sentence, my lord. My lord, I was
Suspension
convicted
of
for,
sentence.
my lord, I was convicted for 3 years and my no wildlife case under, my lord, Wildlife Protection Act, section 51, and no wildlife has been killed, my lord. And I am already in custody, my lord, for 1 year, 6 months, 9 months, half of the sentence, my lord. My lord, for the sake of my submission, my lord, I would like to rely some facts, my lord, upon which this conviction order has been passed by the learned trial court, my lord.
What is the CRAN one?
CRAN 1, my lord, I'm not pressing the CRAN 1. CRAN 1 for, my lord, there was some typographical error, and CRAN 2 is my actual application, my lord.
Okay.
In 438 BNSS, my lord, and 528. My lord, the fact is that, allegation is that, my lord, on 13th January 2023, the petitioner, along with one person, was apprehended from near Cheko Bridge, near Shibari Moor in Alipurduar district, in the daylight, my lord, at 4:30 p.m. And it is alleged, my lord, that from the petitioner was one live pangolin was seized. Now, my lord, during the trial, upon 2 points, my conviction was confirmed by the learned trial court. The 2 points are, my lord, first of all, that there is one confessional statement recorded by the forest official. My lord, kindly come to page number 32 of my divisional application. The confessional statement, my lord. Section 50.
Page
32, my lord. My lord, as per section 50 of the page 32, my lord, of my divisional application.
Yes.
My lord, as per section 50, subsection 8, clause D.
Yes.
Of the Wildlife Protection Act, this statement was recorded. Now, my lord, if permits, I'm going through with the provision, my lord. It says, notwithstanding anything contained in any other law for the time being in force, any officer not below the rank of an assistant director of wildlife preservation or an officer not below the rank of assistant conservator of forest authorized by the state government in this behalf shall have the power for purpose of making investigation into the offense against any provisions of the act, issue search warrant, enforce attendance of witness, and clause D, my lord, that is to receive and record the evidence. And subsection 9, which is very relevant, my lord, says that any evidence recorded under clause D of subsection 8 shall be admissible in any subsequent trial before a magistrate, provided that it has been taken in the presence of the accused person. Now, my lord, if these two provisions are taken in consonance, then a accused person cannot be called to give evidence against himself. It is, I am protected by Article 20, Clause 3, my lord knows better than me. Article 20, Clause 3 of the Constitution.
Challenging the virus of the law. If the application is challenging the virus of the law.
No, I am not challenging the virus.
Yes.
Then the procedure is itself latches. There are latches. My lord, the clause, Article 20, Clause 3 says that no person accused of any offense shall be compelled to be a witness against himself. Now, my lord, unless and until I am coming forward and voluntarily making this statement cannot be recorded. Now, if
so, this provision is not made ultra vires by the any law.
My lord, we are guided with the general ruling.
So you are you want to decide the entire CRR by the.
No, my lord, there are, I'm submitting that, my lord, there are two discrepancies. First of all, this statement cannot be recorded in terms of, there are order of my lord's order. That
I know.
This cannot be recorded. And second point is, my lord, that is the Caesar list, which is itself defective, my lord. The entire gamut of the prosecution's case is based upon the Caesar. Page 23, my lord, is my revisional application, that is Caesar list.
23.
Yes.
23. Running page.
My lord, signature of the witnesses, column 7. There are 3 witnesses has been taken at the time of seizure. First one is forest officer, FR. Second one is also a forest officer. Third one is Bonsho Hayok, forest official. No independent witness was taken. Now, my lord, why no independent witness was taken? My lord, kindly come to page number 27 of my petition. That is the evidence at the time of cross-examination, evidence after charge of the inquiring officer, my lord. My lord, page 27.
Now come with the entire CR. In this case, the CRR can be heard.
Yes, my lord, there were independent witnesses. Miss,
Let the CRR be heard
Listen one thing.
along with the CRAN.
You confine your submission within the bail application. You are going into the merits of the
That's why I am
case. This is
asking,
the-
let the
this is
CRR be
argument.
disposed.
No, my lord, there are.
No, he's doing good. He's a beginner lordship. That's why it is my advice to remain within the ambit of your petition.
No,
my
no,
lord,
let me decide the issue with the
now, my lord, for these discrepancies, even the arrest memo, there is also a discrepancy. Learned trial court's record needs to be called for, and therefore, my lord, there are huge discrepancies which shows that, my lord, the prosecution has failed to establish its case beyond reasonable doubt. Now, my lord, therefore, I have filed application under 438 of the BNSS, under which, my lord, I have prayed 2 things, my lord, that suspension of the sentence, at least, my lord, I am in custody, half of the sentence I have passed in the custody, my lord. And second one submission is that, my lord, learned trial court's record can be called for. Because these are the discrepancies, my lord. Confessional statement
Yes,
number
Mr.
1.
Biswas, when he is in custody, 13/1/2023.
My lord. In the meantime,
13th of January. Yes.
Lordship, may I? He was convicted by the trial court,
Yes.
the court of learned magistrate lordship. And the conviction, the sentence was awarded, rigorous, so far I remember, rigorous imprisonment for 5 years at 10,000 rupees. Fine. Thereafter, they preferred an appeal. And in the appeal, the appellate court, with elaborate reasoning, since there was the death of the animal was not caused by him, considering the circumstances, it was reduced to 3 years, the minimum prescribed punishment, lordship, and the 10,000 rupees fine was remained the same. This is the present scenario, and can you show any document whether you were in bail or not?
Yes.
So these are the considerations. You are going into constitutional provision instead. Now the question is, they have preferred a CRR now. This is not a regular appeal. In view
CRR against the order of
the
district judge.
district session judge,
Session
lordship.
judge.
Because there is no provision of second appeal in the CRPC, and it will change criminal law also. So now the scope is very limited. Lordship.
Yes.
So my submission is, my submission is there are 2 concurrent findings of 2 courts upholding the conviction, lordship. Number 1, when a person is convicted by appropriate competent court of law, the presumption of innocence in a 389 appeal, the similar principles are applicable, 892 principles, the presumption of innocence goes away, primarily, lordship. Secondly, the question of repetition of offense, which relieves there is every chance of repetition of the similar offences. And gravity of the offense, pangolin is a Schedule 1 animal, lordship, and it is a very rare animal. He was found in possession with a live pangolin. These are my points of argument, lordship. Rest, let him argue. He will.
My lord, if permits, I was on bail.
Suspension sentence is a rare phenomenon. It cannot be claimed as a matter of right, especially when the appeal is not on a regular track.
My lord, if permits, my lord, I was in bail during the time of trial, my lord, and there is no misconduct on my part. Secondly, my lord, why I was implicated in this case, because, my lord, I was Upapradhan. It is also record, my lord, that I was Upapradhan, and due to political rivalry, it is from their case, my lord, POR, that there were 2 persons at the spot. In the evidence, my lord, the EO said that he did not find any person in the name of Kumar who was the another person.
Very well, hard.
And secondly, my lord, in revision. Hard. Okay. There was no misconduct. 1 year, 6 months.
Please take down.
My lord, my objections may be kindly be noted.
Yes.
What
And
is a
2
very
of
serious
2024. এটা নট পেশ করতে বলো, এটা নট পেশ করতে বলো। নট পেশ করতে বলো, নট পেশ করতে বলো। Can 1 of 2024. এটা নট পেশ করতে বলুন। Can 1 of 2024 be disposed of as not pressed? Full stop. Can 2 of 2024. This is an application for suspension of sentence according to the provisions of section 438 read with section 528 of Bharatiya Nagarik Suraksha Samhita 2023. It appears that the present petitioner is convicted for offense under the proviso of subclause 1 of section 51 of Wildlife Protection Act 1972, and he was sentenced to suffer rigorous imprisonment for 5 years and to pay a fine of rupees 10,000 ID to suffer further.
That is the
RI.
highest limit of the magistrate, sir. Magistrate.
RI for 1 month. Full stop. Against the order of the learned magistrate, the petitioner has preferred one appeal, being criminal appeal number 28 of 2023 before the learned session judge Alipurduar, who affirmed the conviction, who affirmed the order of conviction, but the sentence was reduced to 3 years. It is the submission of the present petitioner that he is in custody for more than 1 year and 6 months. That is half of the punishment has already been, half of the sentence has already been undergone. So at this juncture, there are sufficient materials to succeed in the appeal, in the instant CRR. So he prayed for necessary order for suspension of sentence. He further argued that during the course of the trial, he was enlarged on bail and he never violated any terms of the bail condition. He prayed for necessary order. Mr. Vicious Learned Counsel, appearing on behalf of the state authority, raised strong objection and submits that there is a very few chance to consider the prayer in the instant CRR. Having heard the learned counsel for the parties and also considering the matter that the CRR is otherwise ready for hearing. So I think it necessary ready for hearing, I think it necessary that the grant 2 of 2024 shall be considered at the time of hearing of the instant CRR. Let the CRR fixed for hearing on 8th of November 2024. Affidavit of service means? Okay.
There are direction of it.
Affidavit of service filed on behalf of the affidavit of service is taken on. That's all? Document? 19, only 19.
But may it please your lordship, my lord. I beg to appear on behalf of the petitioner. But this is a peculiar suit that I have come across, my lord. This suffers from, my lord, total misjoinder of causes of action. And my lord, specific performance has been sought for of 2 agreements. The second agreement superseding the former one, that too in connection with a case, both are unregistered, both the agreements. These were all lease agreement for lease, my lord, beyond a period of 1 year, which were compulsorily registrable, my lord, under the provisions of section 17(1)(c) of the Registration Act, my lord.
Yes.
Now, I filed an application under Order 7, Rule 11 of the Code of Civil Procedure, seeking for rejection of the plaint.
Yes.
Now, my lord, I know, my lord, time is running, my lord. Today, my lord is also in a hurry. I will not take more than, my lord, 5 minutes, my lord, to conclude my submissions, to enable my lord, to also pass an order. My lord kindly takes the order impugned, my lord.
19th of August.
The order impugned is dated, order number 6, dated 19th of August 2024.
Yes.
My lord, I'll just place the order. The facts of the case, my lord, I'll run very briefly. The plaintiff and defendant entered in lease agreement on 26/2022, being serial number such and such, duly notarized on 10/6/2022. My lord kindly marks notarized for running hotel business under name and style Dilkhusha for a period of 6 years. My lord marks 6 years, commencing from 1/1/2023. The defendant is owner of suit premises and same was agreed to be leased out to plaintiff for running hotel business. The defendant received advance payment at the time of execution of lease deed. However, the defendant failed to hand over the leased out property within the specified period. That on 25/3/2023, the plaintiff and the defendant again entered into another agreement duly notarized, when it marks notarized, with a serial number such and such dated 25/3/2023, with certain terms and conditions, and physical possession of the said hotel premises will be handed over on 1/4/23 and the period of lease agreement to commence on 1/4/23 to 30/6/2029.
Okay.
That the defendant handed over the agreed rooms and kitchen to the plaintiff to run the hotel business, but in unfinished state without any amenities of good hotel as promised and agreed in the lease deed. As a result, the plaintiff faced monetary loss and loss of goodwill in her hotel business. That the cause of action arose on 5/4/23, May 23, June 23, July 23, August 23, and 5/9/23 and 25/5/24, when the defendant failed and neglected to perform his obligation by not installing lift services and elevators, water facilities to the hotel premises as agreed in the agreement. The defendant have been deviating his promise by committing breach of contract since the execution of the agreement. In this background, the plaintiff has filed the instant suit. The defendant has challenged the instant suit on the ground that a suit is not maintainable in eye of law and hence the same should be rejected. As such, they have filed petition under Order 7, Rule 11 of CPC. According to the defendant, the plaintiff intends to illegally retain possession over the scheduled property by taking shelter under unregistered agreements despite being served with a notice of termination, my lord, kindly marks this, my lord, notice of termination. The contract, the agreement was specifically performed, and a notice of termination under section 106 of the Transfer of Property Act was served. That has been also pleaded in the complaint also. The plaintiff harps upon two agreements dated 10/6/22 and 25/3/23, and the plaintiff is uncannily silent about the second agreement dated 10/6/22, and the agreement dated 10/6/22 was revoked on mutual consent of both parties. Plaintiff seeks specific performance of an agreement that has already been revoked without consent. Prayer B, plaintiff seeks a declaration that the defendant do not assume any right to terminate the said agreement executed on 10/6/22 and 25/3/23. And it is a well-settled principle of law that a tenant cannot seek relief restraining the landlord from terminating the tenancy or from seeking eviction. Furthermore, the tenant cannot restrain the landlord from beneficial enjoyment of his property. The plaintiff prays for specific performance of installation of lift elevator relying upon two agreements dated such and such and such and such, and in the application dated 13/6/24 under section 151 filed by the plaintiff asserts that the defendant has already installed lift elevator. As such, the plaintiff's suit is rendered infructuous. Two agreements dated 10/6/22 and 25/3/23 upon which the plaintiff's suit entirely rests are not registered, and specific performance upon two unregistered agreements is barred by law. The defendant has prayed for rejection of the suit under Order 7, Rule 11, as the instant suit fails to establish the cause of action and barred by law. Thereafter, my lord, Order 7, Rule 11 has been set out. Now, my lord, kindly take the next page. After, my lord, clause F, that is the finding. From the above, it can be construed that the defendant prays for rejection of claim on the ground that the plaintiff has no cause of action as the lease deed are unregistered. My lord, kindly marks this, my lord. This is the fundamental error, my lord, which has been committed by the learned judge in the court below. The law is very well settled, my lord, that different clauses under Order 7, Rule 11 are not to be mixed up, my lord.
Yes.
Cause of action, my lord, is clause A, and barred by law by any statement is clause D.
Yes.
That is the specific case. But, my lord, the learned judge returned to a finding, assuming that the cause of, since there is, the lease deeds are unregistered, therefore there is no cause of action. Mere fact that two lease agreement dated 16/6/22 are unregistered cannot favor the defendant to the effect that the suit is devoid of cause of action. Especially at this earlier stage, this court cannot come to any conclusion whether such agreement between the parties is valid one or not, or whether the plaintiff still has any cause of action against the defendant. Hence, my lord, my application stands rejected. Now, my lord, kindly appreciates, my lord, section 3B of the Specific Relief Act categorically provides about, my lord, the operation of the Registration Act, my lord, to be enforced, my lord. I'll just place section 3, subsection B, my lord, 1. And that about, my lord, it was barred on the face of it by virtue of operation of, my lord, the Commercial Courts Act. That was also not taken into consideration. It is the duty of the court where, my lord, upon presentation of plaint, to scrutinize the plaint, my lord, to cause an inquiry whether, my lord, there are any statement which makes it barred, because where there is a bar, because, my lord, section 12A, my lord, makes, my lord, the process of conciliation mandatory now under the Commercial Courts Act. So, my lord, kindly takes, my lord, first section 3, subsection B of the Specific Relief Act. It states that except as otherwise provided herein, nothing in this act shall be deemed to affect the operation of the Indian Registration Act 1908 on documents. So this is one, my lord, which was not considered. Second is, my lord, the law as laid down by the Honorable Supreme Court of India, my lord, it is very clear, very well settled that an unregistered lease deed, an unregistered lease agreement creates a month-to-month tenancy, my lord, which is determinable by 106 notice under the provisions of the Transfer of Property Act, my lord. So, my lord, if that is the case, my lord, there is a specific bar under section 4, subsection D of the Specific Relief Act, because Specific Relief Act section 14, subsection D categorically states that the following contracts cannot be specifically enforced. Namely, D is a contract which is in its nature determinable.
Yes.
So that was not taken into consideration. Now, my lord, if I am permitted to place, my lord, the provision of, my lord, subsection section 2, subsection C, clause 7.
Today no more. Today no more. Yes.
Very well, my lord. My prayer is very limited today, my lord. My prayer is, my lord, my lord, this order can be set aside, my lord, and remanded back, my lord, to the court below for consideration afresh, my lord. These points were not taken into consideration. My lord, may kindly set aside this order on the face of it, my lord, because my lord has seen, my
Today it
lord.
cannot be set aside, you serve.
Very well, my lord, may kindly stay this order, my lord, then.
Okay, please take down. The instant CO has been preferred against order dated 19th August 2024, passed by learned judge, learned civil judge, senior division Darjeeling, entitled suit number 16 of 2024. Full stop. The present petitioner, being defendant, have filed an application under order 7 rule 11 CPC before the learned civil judge concerned. The learned civil judge has passed the rejected the said application by passing the impugn order. Full stop. Heard Mr. Bilodar Bhattacharya, learned counsel, appearing on behalf of the petitioner. Also peruse the impugn order. It appears to me that the impugn order has impugn order appears to me not passed in consonance with the provisions of the law.
Grateful to
Not
you.
in consonance with the provisions of law. Accordingly, I find justification to entertain the instant CO. Let the CO be admitted. The petitioner is directed to serve the copy of CO along with the annexes thereof to the opposite party and file an affidavit of service to the court.
Grateful to you, Lord.
Considering the facts and circumstances of this case, the further proceeding of the title suit being number TS.
This is title suit number 16 of 24, my lord.
Pending before the learned civil judge senior division Darjeeling is hereby stayed for a period of 8 weeks from date.
Grateful to your lordship. Extremely grateful, my lord.
Yes.
My lord, I kept my word, my lord. I said not more than 5 minutes.
Before
I take
your
that.
lordship rises, my lord,
Grateful to you, lord.
Lord, once again, my lord, making the
No,
prayer.
today we don't have a time. We have to take
My lord,
the.
I am carrying, my lord, your lordship's order, my
We
lord.
have to take the.
My lord, only, my lord, the FIR number request to be changed. My lord, the police
Very
is
well, thank you.
continuously harassing
Thank
the
you.
directors, that's why.